want to talk about the purpose of the corporation and sort of what it's about?
You get very political when you talk about it.
I don't get very political.
It's a political conversation, but I'm very realistic about it. This is also nice, I think. But what I think is the most yes, this kid must have left very early to be
Right.
here. What I think is, which is very interesting, is I think you should talk a little bit about shareholder-centric and director-centric, and maybe how this affects the corporation, right? Because, the director-centric thing, the critique is that came from the German law.
Não vão se arrepender.
That came, and it was a way that Hitler would use to control.
What the shareholder-centric?
No, the director-centric, meaning.
It's not really how our law came about. So
I do know that.
we didn't. Hitler was, even though the DuPont family really much admired Hitler.
No, I know.
Do you know the part of the DuPont? The DuPont family hated LBJ. I mean, the LBJ, FDR.
Yeah, they were reporting it,
They
right?
thought he was a traitor to his class, to the rich. They thought he was a traitor to the rich, and they like Lindbergh played footsie with Hitler, and the abdicated British king did.
At that time,
We're deciding what to
you
talk
know,
about.
there's a lot of letters with Einstein and with Gandhi and Hitler. I saw in Gandhi's museum several letters. At the beginning in Europe, they didn't see.
Yeah, they didn't understand. Well, plus they also saw they were hungry for effectiveness. Remember, Mussolini inspired them all because Mussolini.
And they didn't want
You know why he
another
had,
war, actually. After the First World War,
The head of an aviator, because he was trained in Italy to be an aviator in the Army Force, so he would always be pictured with that head as an aviator.
Well, you want to know a football thing, and I didn't realize this because I was a kid. You got to be very careful about Lazio if you root for them. Lazio has some symbols that are considered fascist. Yeah,
I agree.
because Roma was associated with Mussolini's regime, and Roma is more the club of the people and not the government. And Lazio was associated with the fascists.
If you go to Pakistan, all the Muslim walls, the swastika cross,
Yeah,
it means
it's something
peace.
different. Yeah, it's something
the
different.
Same. It's the same.
No.
drawing.
I know it's
And
the
it
same.
has that
I know
meaning.
it's the same drawing, just a different meaning.
No, the meaning that Hitler wanted to put was the same. It became the synonym of evil.
Of course.
I was astonished when I saw this.
right.
You see it in the wall. Look at this.
Joana,
Look at this. This is an amazing thing. Look.
você sabe que você foi substituída, né? Você sabe que nós temos uma nova Joana.
This is the main space.
Cara, ela é igualzinha a você.
They're still
Ela é igual a você, só mais bonita, mais inteligente, mais popular.
draw people. They could only draw. It's beautiful.
Aí tem saudade de você, cara, mas você precisava conhecer essa menina, ela devia ser sua irmã.
Mas eu conheci ela, eu fiquei ela falou, mas não é isso.
Não é isso que eu tô dizendo, mas ela é sua irmã. Faz muito bem.
I was saying, Julian, I'm still not sure what we're doing today, and what you think, Chico, is most helpful to the student.
I was suggesting a discussion about, which is something I had to do in class, shareholders-centric versus director-centric legislations. A comparison on how this is different.
Let me introduce you to Vinicius Castro.
A professor,
He is a brilliant professor of economics.
He's a liar.
We teach together,
and
and several of the economic students are there.
he's a great mathematician,
Brilliant.
And he plays for Real Madrid.
Vinicius,
You know,
yes.
Is that your son, Vinicius Jr.?
Almost.
Does he send some of his? Does he send some of his salary back? That would be a.
Vinícius, senta aqui, Vinícius.
Vai ter que fazer pergunta inteligente, hein, Vinícius?
The second time I see you, it's amazing.
These cases that were important to the development of the recent years.
But do you agree that shareholder-centric versus...
But they know that already.
Well, how about? Do you want to talk a little bit about the?
But what do you think is better?
Do you want to talk a little bit about the debate, how that relates to also the debate about the purpose of the corporation that's
That's why I think it makes sense, because then you can do this connection to a subject that's very dear to your heart currently, which it obviously is.
Well, we can also talk about some of the assumptions behind corporate law that related to the way societies work. One of the things is, for example, you know, the
Good
state-
morning.
Good morning, Professor.
Oh, how are you?
Good. And
Hey, Mr.
statements,
Nick.
what's good for GM is good for the US.
Very well.
That's a terrible statement.
No, that was in the 1950s.
Yeah.
Foi bom ter isso.
GM,
O diretor,
the way it used to work is that the company and
o Roberto.
the community did better. They employed more people. They employed more people in your community. They usually invested back in the community. Now the way corporations are, it's a very different.
Depends on the side of the corporation, right? The medium-sized industry will create jobs in America.
Yes, but what I mean is there's not as much necessarily making not necessarily.
Lá de influência.
It may not even community. May not even create jobs in America.
Rio de
It
Janeiro.
may create jobs that are cheaper.
I agree.
Foda.
But then you have to think that if you consider it from a worldwide perspective, if you create jobs cheaper,
O ar-condicionado tá ligado, não.
it's a
Falei
cheaper
com o Caio aí pra dar um.
and then you are
Oh, obrigado,
you're
Vinicius.
taking wealth, yes, from America, but in a certain way.
Child labor.
If you no, I'm not talking about. There is a limit to that. I agree, and that's not all child labor.
And
That's an
some, no,
exaggeration.
and some of the stuff with,
That's an exaggeration. Meaning, if an industry prefers to produce in Brazil than the United States, if you think about it from the human perspective, you know, we are poorer than the Americans. So we have to be careful with that. Not as an American, but you know, as,
Oh, no, no,
as,
but what I mean is-
a human being. Fear. Vê com eles lá o ar-condicionado, tá bem fraco. Please.
I don't talk about all the decisions that you make. They be a paradigm. For example, I always like to hear the story of Joe Minerals, and I heard it from Mark Lipton several times, where he invented and why it's called, why it's planned.
But he already talked about this last time.
But these are news too.
Well, some of them are not, but okay, let's do it. We can do it.
You can talk about the field, you can talk about the intensity, the calculation, the obligation.
do they like takeover defense?
Yes, they do. They love it.
You know, some of them are young; they don't even know what this is. So then you will explain, and they will love it.
The economics.
Like, what course is this? Is this an introductory?
No, this is open. Anyone can be here.
Okay, students of my class, they are already studying, they know what is defense. The economics guy, this is the back there, some of my students, they know exactly what it is and they have a very mathematical reason.
Okay,
So you can talk.
here you have also a lot of
Does it make a company
the corporate law
perform
one
better
students
without
which
contact
still have
boards,
not studied what control is. So you have a sense.
target boards, cumulative voting, all of these protections are no longer something important for the shareholders. What is important for the shareholders today?
That's a good question.
It's changing a little bit. Well, I mean, takeovers happen all the time. I mean, that's the thing is there's no real barrier to it.
And another discussion which is interesting is your concept of, did we talk about this yesterday? I'm so confused. We talked about so many things, so many times. The separation between ownership and ownership, that I just love. That, did we do this? Obrigado. Thanks.
That's an interesting subject. I like that too.
But have we talked about it yesterday here? I don't remember. We talked about it so many times. Do you remember if we talked about it
It
yesterday?
was nice to you. Or...
Yeah. No, he's a dick.
Yeah, he's a great boy. Come on.
No,
He,
Fran is one of the nicest.
he obviously
Fran is
has
one
a
of
lot
the-
of his mother, right?
Fran is one of the nicest
He's-
people I've ever met.
And Fran is actually not very, Chico and I, similar on that. We are not very shy. Fran is
Try not shy. Try is discreet.
discreet, yes. We are not. You and I, we're not.
No, I'm not.
Well, it's interesting that he's a litigator too, because, but also that kind of quiet charm.
We have Commissioner
can be very
Gustavo here
persuasive.
again.
Did he tell you that-
Gustavo, muito orgulho de ter você
Yes.
todo dia aqui, hein? A Flávia disse que ia tentar vir também. Não tem problema nenhum, não.
Fala, Gustavo.
Yeah, I guess,
Professor
I guess they
Gustavo.
should do most of the international. They must do most of the international flights.
Yeah,
Overnight. So I go into Miami, then Miami to Philly.
You promised that you can come back next year
Why
with the
not?
family.
I actually think we can, because I said if they're going to the same college, their spring break. Their spring
So
break
this
will
is
be.
a very good time for you to come. It's the nicest time of year.
Yeah, no, but the time that it might be during their school would be late summer, which I know is very hot, but
Late summer is what?
late March.
Once we start with the classes, you can come.
Você é autoridade, né? Não, Caio.
Fran's going to New York for a week, he said. I told him he's going to get admitted to the bar, and
Hope so.
Ele está reclamando.
it's all done. He just had to go do the
A
ceremony.
autoridade está mandando você vir para frente.
How'd you like to be a goalkeeper?
É a
This is one of our
Fernanda.
few players.
A autoridade aqui é a Fernanda.
World class. He was the best goalkeeper at World Cup. He played
He's a
seven.
good guy.
Brad Friedel.
Yeah, Bradford.
But he got fired. His team gave up.
Should
His team
we,
gave up 18 goals.
should we start?
4 games. So, but the owner of the team. What is this first? I'm going to give him a historical.
Vou fazer minha coisa de ontem. Alô, alô. Bom dia a todos. Eu vou começar essa apresentação em português. Eu, em primeiro lugar, queria cumprimentar todos vocês e agradecer a participação, mas eu quero agradecer em especial meus alunos de economia e o professor Vinícius Carrasco, de economia, a quem eu peço uma salva de palmas, por favor. Eu gostaria de pedir ao professor Pedro Paulo que fizesse, por favor, a abertura oficial da nossa sessão de hoje.
Está aberta a sessão.
So, guys, now we'll switch to English so that Leo can also laugh about our jokes. So, what we're doing today is
I understood him. I just didn't find him funny.
so. So, it's terrible when you say a Professor Pedro Paulo joke is not funny. It's like a crime, and you can go to jail forever in this country.
I just assumed it was a deeper point I didn't understand.
Okay, so today, Professor Strine, whom you all already know was Leo, will talk a little bit about some other general concepts which are very interesting and try to compare some important issues like why you have jurisdictions which are more shareholder-centric, others which are more director-centric, how it came about in the US, especially in Delaware, which is very interesting. And he would also like to, probably he will talk a little bit also about the purpose of the corporation, which is an important subject. It's a little political, also legal, but he has many views on what's happening around the world on this subject. And he's, of course, being very much heard about it everywhere in the world, which is nice for us to have this view and listen. And then we'll see where the questions go, and then we'll, develop a discussion. Now, many of you already been here since yesterday. Okay, you came yesterday, you are now here again. So you probably will be a little bit less shy and be able to ask more questions, and then we'll go from there. Okay, Leo?
That sounds good. And I would encourage students, I think at some point in this, we ought to just open up to you any questions you have about the U.S. business context, the legal context. I'm here to be as helpful to you as possible. So are your professors. That's part of why this great institution exists. I do want to give you a little historical perspective, because I think when we talk about shareholder-centric versus director-centric, and some of you are economic students, but you'll hear these buzzwords too, and you'll hear about the Chicago school versus the other thing, and unfortunately it's not about blues. It's about, form of economics, right? The Chicago School of Blues is quite good. If you ever get a chance to go to Buddy Guy's, it's a really good experience. Get a big steak, and it's pretty cool. But in the United States, we've had a historical debate, and I think it goes on in other nations about what is this thing? What is the corporation about, right? What is the ultimate end of a corporation? Is it about just the best interest of the stockholders, the people who invest in this capital? Or is the corporation to have a purpose that's conceived more broadly, Julian, to actually encompass the best interest of not just the stockholders, but of the employees of the corporation? How about the communities in which the corporation has facilities? Do you have to have regard for them? Do you have to respect the environment in the communities where you operate? You're consumers. If you sell products, right? Fran and I had a crab thing last night. There were some nice things we ate, but I'm not sure how long I'm pretty sure it was not out of the fresh waters of the Atlantic anytime soon. And so, is that what you want to serve to your customers necessarily? It felt a little weird, yeah, but and I didn't drink enough to account for that to account for it. But I'm just saying that no, it was fine. I'm just saying no. I had other stuff was great, but my point is the company something larger than just the stockholders? And if you're governing the company, to what extent, if there are choices to be made that may involve, it's not always the case, right, in life that you can have everything you want, right? No, again, we talked about this. There are people like Giselle and Tom Brady. Maybe you can, but I was talking about this in terms of the idea of what's the faith where you come back in another life? Yeah, well, and there's a faith where like next time you might come back as a different caste or as a different animal.
That's Hinduism.
Hinduism. Well, no wonder, no wonder Giselle and Tom Brady are so nice, because they know it can't get better than this. And so the next few lives, they better, right, exactly. But for most of us in most lives, we have a trade-off, right? The company's doing really well. To what extent do the blessings that come with that, the company's increased its profitability, the company can safely use that cash in a way that's not necessarily reinvested into its businesses, it's paying off its creditors. To what extent should that go into some increased wages for the employees who helped create that wealth versus an increased dividend for the stockholders? In tough times, the opposite. We have to cut costs. Does it come out of the workforce or the stockholders? What is our duty if we're running the company then, right? So there's been this debate in the US for a long, long time. It actually goes back to Henry Ford. um, about this and about whether you can consciously take action to benefit other corporations at the expense of other constituencies of the corporation at the expense of stockholders. And we've never quite answered that. But the answer of the business, the way we always rationalize it was sort of short versus long term, right? Have any of you ever been out to Silicon Valley? Any of you ever gone there, right? Google has this cafeteria where you never want to leave because they have like Italian Thursday, Brazilian Friday, Thai food. They have dry cleaners. But part of why they're doing that, why do they do that? They want to get the best developers. They actually don't want you to leave the campus. So one of the things about paying a workforce, if you invest in your workforce, say, well, you should have increased the dividend. You say, well, we need a good workforce. So the business judgment rule, part of the business judgment rule reason why it exists, Julian, is to give directors the protection to make these kind of choices. But ultimately in Delaware, and I think in most of the states, it's called the business judgment rule for a reason, and that your judgments about benefiting other constituencies have to have a rational relationship to the best interest of the stockholders. Which is, for example, what if you help raise money for a local hospital? Well, you can say, look, we have the factory in that town. Our reputation in that town is important. That is where our workers get health care, and that's important to us. If you were to flat out say is, well, we actually, no, and our law does too, but this was controversial, was an evolution over time in the states of whether you could do charitable contributions. Because there was an argument, we talked yesterday about ultra vires, the idea if it's out of a power. The point is, why are you giving away the company's money for a charity? So there was a thing basically, and maybe in the Brazilian law, that it has to be reasonable. You can give raises to workers and other things, but there's always this rational relationship test. But there's been a balance throughout time, and I'm not going to bore you or make you read the cases of going back and forth about the purpose of the corporation. Very famous debate, in fact. Even though Adolf Berle, who we talked about yesterday, was a big believer in the economy working for all, he was also a person who said corporate law itself is mostly focused on stockholders. There are other areas of law, worker protection laws, other things. A company law, a lot of it is between the managers and stockholders. But here's the interesting thing in the US about the stockholder-centric model versus direct, because that's a different, there are questions of means your professors will talk to you about, right? And there's questions of ends. Means are tactics, right? Like football, when you play a match, your goal is to win, right? Even Brazilian teams play ugly to win. You picked a non-Brazilian to be your World Cup coach one time because you thought he would help you win. The non-Brazilian being Dunga. I just say that because it's not exactly the beautiful game, Dunga. But he was pragmatic, right? You choose in a game, what's a mean? A mean is, do you play 4-4-2? Do you play 4-2-3-1? Do you play with two holding midfielders versus one? Do you push your outside backs up to attack? Or, right? That's a means. An end is, what is our goal to win? And I think, Julian, you have to think about this dimension. You'll hear in the students, director-centric corporate law. That's really a question about means, which is, and I'll put this to some of you study political science. Any of you study a little bit of political science? Do you understand the difference between a Republican form of democracy and a direct democracy? Direct democracy is when the governed vote on everything, right? And you have to go to the people to make the decision. Republican democracy is you elect the people who govern. And during their term in office, they have to use their best judgment about what's good for the people who elect them. Well, corporate law, as we talked about yesterday, uses both these tools, and when we talk about director-centric versus shareholder-centric you can think of as direct democracy. Director-centric you can think of as Republican democracy. These are questions about means, not ends, because we have a state named California that you may have heard about. Pretty cool, right? Songs about it by the Beatles, Beach Boys, all kinds of things. But it was actually, it's going through a renaissance, but it really, hurt itself very badly over 30 years by going to direct democracy. They used to invest in their universities, in their roads, in their infrastructure, in their people. Then they went to, we're going to have what they call referendums to get it where the people could directly decide, we're going to cut taxes, we're going to do everything. Really hurt their university system, hospital system, all kinds of things, because they didn't give the people they elected the space to govern. So there's a debate in the US, and we actually call it corporate California, I do, which is, do you want a company where you elect directors, because we elect directors every year, where you not only elect them, but then whenever they have to do anything, they have to go get your approval. And not only that, that you can actually put in ballot initiatives in to tell them how to govern the corporation. Delaware is more like a republic, Julian. And I think what we would say about this is there are systems, and we talked about Brazil's system of shareholder-centric, where the shareholders can act pretty much constantly like a direct democracy. Our system is a bit more like a republic, where, and this is where the business judgment rule comes in, which is during your tenure in office, you're supposed to do what you think is best. The business judgment rule protects you when you're engaged in impartial decision-making. And we believe that out of the giving you the flexibility to innovate will come the most value for everyone. There are certain things you do, we talked about yesterday, merge the company, right? You're going to do a merger. That is so important that we use a tool of direct democracy and say that we actually are going to require a vote. But even in that, Julian and Chico and Professor Pedro, our motive force under Delaware law is really from the board itself, which is the elected representatives through the board come up with a merger or something, and then they put it on the ballot. Not that there's so much referendum coming from the stockholders. We do have an AGM, but we really don't have, you know, the stockholders are allowed to amend the bylaws and do a few things, but it really is more of a republic. But where this comes into the purpose question is, right, and I'm involved in this debate in the US, and it's a big debate now in the EU and the US, is there are people who say, well, the purpose of the corporation should be about just the stockholders. As long as the company, and remember we talked about yesterday, I don't know if we mentioned this, the bottom line for a corporation is any lawful, in Delaware, is any, you can conduct any lawful business by lawful means. So you have to comply with the law, which means, it also means honor your contracts, but it really means don't violate the substantive law to make money. There are people who would argue, once you do that, your duty is really to focus on the stockholders. And it's there exclusively, really, the end of corporation. And it makes the other constituencies, to say the means, it makes them the means. You can consider the workforce, right? And their best interest of giving the workforce a raise, treating them well. Others would argue that that's silly. We don't create human institutions to do that, to be that focused on just one constituency. And really, you have a duty to the company writ large, conceptualized as involving all of its constituencies. And no constituency is necessarily more important than another. And then the people would have it is the elected representatives, Chico, will determine what priority to give each of the constituencies. Then there's the variations, like the stockholders sort of are a plus factor. The other ones can be ends as long as there's not a direct sort of conflict. As long as you can, as I said, rationally relate what you're doing for the other constituencies to being consistent with the interests of the stockholders, you can do it. But here's where the power, like purpose, talking about purpose without considering power is kind of naive. Part of what Adolf Berle, we were talking about Orwell the other day, Professor Pedro Paula. Orwell, one of the reasons why Orwell is one of my heroes in Adolf Berle is they looked at the world the way it is. If you really want to make an impact on society for the good, you have to understand the actual dynamics that you're trying to address, right? Because we can wish away all kinds of things, but that's not going to get you anywhere. addressing the thing. And here's what in corporate law. And anybody know rock and roll? I know your generation is not interested in rock music, right? It's dead. Rock is dead. And hip.
They like chanchado and aquele happy de uma música maluca, né?
Well,
Rock and roll is not that.
no, I know, but there's a
Not for us, but for them.
Is rock and roll dead, people?
there's still some rock and roll, but there's a great song called "Summertime Blues," which has been covered by a lot of people, but it goes back to the late '50s by a guy named Eddie Cochran, who was actually a hero of the Beatles. The Beatles were great students of American rock and roll, but the "Summertime Blues," why it's apt to corporation law is this, and I use it. It's a song, and it's about people. It's about a kid in the summer. It's summertime. He's a teenager in the U.S., and he's having problems like he wants the car for a date with his girlfriend, and his dad won't let him borrow the car. All this kind of stuff, and he's got all these gripes. So he goes. Our legislature, we have U.S. Congress. So he goes to you have a congressman who's your local person. So the line in the song goes, "I called my congressman, and he said, quote, I'd like to help you, son, but you're too young to vote." And the point is, if you could vote for me, maybe I'd listen to what you cared about. But since you can't, go deal with daddy. Well, in corporate law in the U.S., who gets to vote? Do the workers get to vote? No. Only if they own stock. Does the community get to vote? Only if the community members own stock. Does the environment get to vote? Only if the trees own stock. Actually, some of the marijuana buds may be wealthy enough soon to own stock. We're going to give the cannabis a 401k program, Chico. It could be a good thing. And but my point in this is, so when you talk about purpose, you have who decides here, right? At the very best, you've got a combination of stockholders. So stockholder centric. If the only people who are stockholders who actually have a vote are the stockholders, who are they likely to favor? But then even if you have a Republican form of democracy, which is that the directors get to decide, if the only constituency which elects the directors is the stockholders, does a statement of purpose mean much if it's not given legal power behind it, right? And so one of the things that happened in the 1980s, we had this wave of takeovers around the country where people were coming in and making bids. And the companies, these were, companies that were important to communities, and people did not want them to be taken over. A lot of states passed constituency statutes that said the following. In the context of a takeover or any other business decision, the board of directors may take into account the best interest of all the company's constituencies and do not have to favor the stockholders. A majority of American states actually have these statutes. You know what impact they had? We have a Yiddish term. U.S. has it because we have so many different cultures we use terms of all this language. There's a Yiddish term called bupkis. It means nada. It means nothing. That's what impact it had. Can you guess why, students?
Why?
Anybody know? Well, think about it. Yeah. Well, and the point is, I think you're exactly right, which is they could either migrate against it or migrate against it, or I'm on the board of directors, right? That's nice you told me I can favor the other constituencies over the stockholders. Yeah. The people who vote for me are the stockholders. And so, no. And so when the takeover comes, right, I'm thinking about this going, the people who elect me want this takeover. Now, it had this impact actually. You know what management did? Management made deals for themselves, and boards made deals for themselves where they would get severance packages to favor the takeover. But the other constituencies that were given no power to go along with the stated purpose did not benefit. And in fact, the American labor movement, the union movement, felt really used because corporate management had encouraged them to support these statutes. But none of the statutes got used to benefit the workers because there was no duty behind it. Like it was you may favor. Well, you may favor, but the people who elect you are the stockholders, not everyone else. If you don't do what they want, they will unelect you at the next board meeting. So maybe what you do is reach an accommodation that's good for you, but you're pretty much going to do what the stockholders want. And so, Julian, the fact is, there's no real evidence that in the other states where this happened, boards behave differently in the takeover context than in Delaware, where we don't have this. We do not have a statute that says that. And then there's the thing, students, you learn about power and purpose. One of the things that, doesn't it say something about the purpose of corporate law? That the statute, right, and I said yesterday, we do have common law corporations where the judges decide, but the statute is the foundation and is supreme. It says something about the purpose of corporation law in the US, that the only constituency given statutory rights is the stockholders, right? You can have company laws. Germany has them. Some of the Scandinavian states have, where other constituencies are given rights. Under our statute, the only constituency that elects directors, gets to sue directors, gets books and records, gets to vote on transactions is stockholders. It's hard to believe that that's not an insight into what the purpose of company law was, right? It doesn't mean that the company doesn't have to comply with other laws, but it does mean that those other constituencies really have to rely upon those other laws. But here's what's going on in the US. And I'll use a famous statement. If you read US history, 20th century US history, you're likely to come upon a quote by a guy named Charles Wilson. He was the head of the Business Roundtable, and I believe he was the head of General Motors. And in the 1950s, he's basically said, what's good for General Motors is good for the United States. And that's been laughed at a little bit, but it was in its time there was many elements of truth to that. And what he meant by that was, if you think about businesses in the 1950s or 1960s, even though the world was globalizing, and even though companies were nationalizing, which is getting larger in scale, when a company did better, right, what were the things that happened? Generally, if your company did better, it grew and increased employment. Generally, in that era, stockholders were actually more dispersed and quieter. There was more gain sharing. So that if the company profits increased, yes, we'd increase the dividend, but you almost certainly increased the wages. When companies got more profitable and grew in a community, they tended to invest in the local hospitals, the universities, and in playgrounds for their employees' kids to do. And that there was gain sharing between the communities. There was an alignment of interest. Fast forward to the globalizing world of the 1990s and 2000s, where equity capital has really become much more aggressive, where companies now were under pressure to increase profits while facing competition from abroad. And what you see throughout the OECD nations is less gain sharing between the workforce of the companies and the stockholders. And I think we may have mentioned yesterday, but you think about our Trump is the Brits' Brexit. And a lot of that comes from increasing economic insecurity. And what's occurred in the US, and there's a bill in our Congress, is this bill, Julian, about the purpose of the corporation and about requiring every American company, public or private of a certain size, to be multi-constituency. But the bill even goes further, and I do think it addresses, I'm not sure in a way that is going to pan out, but it shows the debate that's going on. And it's important to you as young people, because you care about things like the This is also in the question of sustainability, right? Climate change. How are companies making money? The bill actually calls for 40% of the board to be elected by the employees in some way. It doesn't talk about how. And this debate that's arising is about the gain sharing and about whether the companies are working for everyone, because there's a feeling that the companies are focusing too much on the short-term interest, in particular of the capital markets and their demands, that when it comes to figuring out how to make money, the people who suffer, the constituency that suffers the most is the workforce of the company. That there's pressures for companies to cut corners in terms of environmental compliance, to locate jobs in places where you can have child labor. So this is the debates that's going on. And it's a very vibrant one in the US. And there's a new form of corporation, actually, in Delaware has it, called the benefit corporation, which you can elect into, where the corporation goes from a may duty, and this is in Delaware law, you can elect into a form now called the benefit corporation, where the board of directors has a shall duty. You shall operate in a sustainable and socially responsible way. And you shall consider the best interest of your workforce, of the communities in which you operate, and of your society.
That's a command to the corporation, not to the director.
No, to the directors. Their duty is a shall duty. And here's the way it works. It's still conservative in this sense. The stockholders elect the board, but there's a supermajority provision that protects the benefit. What I mean is, when you've committed to this form of governance, in the context of a sale of a corporation, for example, you would actually have a duty. If there was a $44 bid, imagine a $44 per share bid, that was the highest bid. But the buyer is a buyer who offshores its jobs to a nation where there's no labor protections, there's child labor. They have a history of doing this. The other bidder is at $41.50. Is got a record of social responsibility, treating the workforce well, has committed to keep the workforce employed. The directors have a duty to actually do what is in the best interest of all those constituents. And they are actually authorized to take the lower bid, and you can be sued for actually taking the higher bid. Because it genuinely does not, what this does is it does not allow you to advantage the stockholders. It's a question of business judgment, but you have to always act in the best interest of all in a socially responsible way. And the supermajority, the way it protects it, Julian, is to get rid of the commitment to be a benefit corporation, you have to get a supermajority of the stockholders. So it's still conservative in that sense. But if you imagine that there might be socially responsible funds that would invest in those kinds of companies, index funds, the workers own if they get equity. And so that's a movement that's going on. And
Can I ask you a question?
sure.
Suppose your bid of 41 is from this horrible guy, probably a company that is exploiting Africa,
Right.
doing something bad, slave jobs and all of this.
Like they
The
work
other,
at, they
the
like they
other
work at-
bid of this social responsible guy is $20. So it's 41.
Well, then you don't sell.
Then you don't sell at 41.
You don't sell
or
at
you
all.
don't sell at 20.
Yes, exactly.
Where do you sell? I mean,
Well, no, but I mean, I think that's, look, this is where it comes back to being fundamentally conservative. And it also comes back to part of having power. Do you notice this in your politicians, right? We have it in the U.S.
which politics? We don't have.
No. What I'm saying, you have leaders. You have Aristotelian exemplars of philosophical judgment and heroic wartime courage. In the U.S., we have people who like to be elected, and they like to get authority. But then when anybody asks them to exercise it, they say how difficult it is, and you can't expect me to make a judgment. With authority comes, yeah, if it's not a good price where it's a profitable time, if the company is better off not selling to either bidder, Chico, it's a matter of business judgment. And so the point is there's judgment, but your judgment, what I'm saying is, I had the bid, you know, $44, you can get 44 for the stockholders, but you're really, to use the technical American term, screwing the other stockholders, or another technical American sort, hosing the other stockholders. I mean, the other constituencies. Or you can take the lower bid, which is still, imagine it's still a favorable price, $41. It's still, let's say it's a 40% premium over market. The other one is something else. So it's a profitable deal for the stockholders. It's in their best interest, and it beats the, you know, we've got economics professors here. You can get this without the risk of executing on the business plan. You actually have the discretion and frankly, probably the duty to take the lower bid. Because one of the things, and I think no, well, that's what I said. It expressly, we had this duty, the thing I mentioned yesterday, that you have to sell an asset for the highest price. It expressly tempers that Revlon duty. Because I think anybody would tell you when the end game is. Have some of you who are economics been taught this thing about residual claimants? Think about the way the residual claimant model works and why it really doesn't model the world, right? The residual claimants, so-called, for those of you who are first year, the idea is this: there's a pie, right? And there's a claim on the pie by everybody who has a contract with the company or society, if there's a law, or workers. Everybody who has a claim, a legal claim to the pie, gets their share of the pie before the stockholders eat any pie. That's the theory. And therefore, if we run, the people who aren't guaranteed any pie are the stockholders. So if we run the thing so it's good for them, we're gonna make the most pie, because they can only gain, right, if everybody gets their guaranteed pie. But that kind of assumes the company's going to liquidate, right? It kind of assumes, okay, in 20 years from now, let's sum up the thing. You stockholders stay on the sideline. Don't take any money. You wait until we see how that pie grows. And then the court's going to supervise making sure everybody else gets treated that way. Well, that ain't the way the world works. Stockholders eat pie constantly. Every time there's a special dividend, tasty pie, right? In takeovers, when you see bankruptcies in society, right? Have you seen bankruptcies? Where companies pay too much for a good company. People come in and pays too much for a good company, puts leverage on the company, destroys it. The workers lose their jobs. Many times communities have made investments in the company. In the United States, corporations pay very little local taxes. When they operate, they almost always ask for subsidies. You saw the big debate about Amazon in New York. Well, when they do the takeover, when they go bankrupt, well, the stockholders got their premium. Everybody else is still working for the company or doing their thing. So this whole thing about the pie and all, just be very careful about that, because it doesn't really describe the way the world is. And I think one of the things in this context, Chico, with the Revlon is to say, you know, we're going to sell. And you've got to make sure the sale is good for the stockholders. But if making it best for them makes it actually harmful for everyone else, you shouldn't be. These other people have contributed to making this corporation, right? You shouldn't be doing it at their expense. The supermajority protects that. And the way I would also analogize this, and I know it's true in your society, you think about small proprietors who run a restaurant, run a business, and they don't necessarily have children who want to take over the business. They're not as wonderful as Professor Pedro Paulo or some of you. You know, I mean, there's a big Brazilian tradition of people working with their children. It's great. But sometimes your children don't want to run the restaurant. But you've been running the restaurant for 25 years, and your manager is a great person, and she treats everybody well. All the workers love her. You love her. You know the thing. You could sell to someone else, and you could get more for yourself. But you know she helped build the business, and you know that the people that work for you trust her, and you know that she'll treat them right, and and you care about your customers too, and you know that many times that business person will sell, right, for a good price and ignore the blowout price from someone else, right? Because they're saying, ethically, who am I as a person? I mean, I want to get a good price for my business. I built this. But part of why I built this the way it is, part of why we treat our customers and employees this way, is that's an expression of my values too. And so part of this in the benefit corporation, Chico, is to give the directors, but it is still fundamentally conservative, if you notice, because it depends on, and even the supermajority, right? It depends on there being at least a base of stockholders who are going to protect the benefit. But it's a big debate in the US right now because your generation of entrepreneurs, a lot of them people are saying, we want to make money the right way. We want to operate in a socially responsible way. If it's more difficult for us to drink our suco because the straw is falling apart as we suck it, but that's a socially responsible straw, we're prepared to do that, right? This is a debate in the US, Chico and Julian, Professor, about how you do business. And just to give you a comparative thing, and then we can maybe open up the students, this is also big in Europe right now. In the United Kingdom's new corporate governance code, they require that you either have a director elected by the workers, a director who advocates for the best interests of the workers, or a workforce committee of the board, for precisely the same kind of reasons. And they also strengthened the purpose requirements under the UK code because they've struggled, right? They have actually a multi-constituency purpose corporate law, but they have one of the codes that gives directors, Chico, as you know, the least ability to block a takeover. And so their purpose statements haven't really panned out well. So the British have actually reoriented their system to give more insulation to the board to think in a multi-constituency way. And they're actually imposing duties on the board to think more directly about other constituencies, precisely because of the concerns that manifested themselves in Brexit. And throughout continental Europe, actually, you see more of the countries, Chico, opting out of there was a takeover directive that really would have limited the ability of boards to really block takeovers. More and more European countries have opted out. And so this debate, Julian, about power and purpose is really front and center in the US and throughout the OECD now. A lot of it is driven by the difference in gain sharing between the workers and the stockholders that used to exist, the growing economic insecurity and inequality that has come with it. And so it's a very salient, politically salient discussion, and I think a healthy one, about what we're trying to achieve when we use corporations.
Leo, here's what I struggle with on this. I think it's pretty obvious that from a cultural and an ethical point of view, people should take all these issues under consideration. My problem is when you put it in law. I'll tell you what I mean. If you put it in law, it means a judge or a jury, someone may enforce it, right? Because if it's in law, then you have this principle that you have to comply with, or this, this rule, which is, as Chico was pointing out, kind of open. So if you say, okay, you have to take care, you have to consider, well, one thing is the law. The law says you must do this and this and this, and okay, it's a labor law, environmental law. But then you go to directors and say, look, guys, the law now says that you shall take into consideration the other constituencies. And our law says, which you must loyally respect. That's the wording of our law. So, and I'm talking about the controlling shareholder, not the directors, but it's, for Brazil, in this case, would be the same thing. Yeah, would be the same thing. So what I struggle with is, how does a judge enforce that? Because, judges know about law. They don't know about what's better for each constituency. So
I mean, it is an interesting question because people argued that if you let directors imagine a business judgment, right? At least it's always uncertain, right? They say we did this because it's good for the stockholders. It gives the court a benchmark, right? To assess, and what you tend to do with anything, right? Part of what you do in law and various areas of law is look, why did somebody do something, right? And then you assess, well, if they really were trying to achieve that in good faith, how would they act, right? What this does, and so the point is, it only makes it a little, I think Chico's right, and we've written it, we struggled with this when the benefit, but it's a business judgment, which is it doesn't say that every employee is going to get what she wants or that the community is. It's that you're accountable for doing it. If you have a rational process and reach a rational judgment, then you get business judgment rule treatment. But you also get to say this, the stockholders sue you. And where I don't really understand your question about law is this. The idea that law is not already shaping incentives. This is not true. Chico mentioned the so-called Revlon. We have a case, a really strong case that says when you sell the corporation, when you're going to sell the corporation for cash, you're supposed to try to get the highest value reasonably attainable. That's law. If you want to address the incentive system set up by law, there's really no other way to do it than by law. If the law says that the only constituency that gets to elect directors is stockholders, that has an effect. If you want to address potentially if society believes that effect might not be optimal, there are a range of options to deal with it, including giving the power to elect some directors to other constituencies to address the duties of the directors. But it's hard to ignore this. And here's another thing we should mention about the U.S. We had the separation of ownership and control, right? You've heard about that a little bit, which is we had dispersed companies, the idea that people were running companies and yet the dispersed stockholders, you were worried about how responsive they would be if the stockholders were dispersed. And one of the things I kind of missed a little bit is we changed the dispersion. If they're not as dispersed, they're concentrated. We have mutual funds in the United States. 4 mutual funds own about 15 to 20% of every listed company. BlackRock, Fidelity, State Street, Vanguard. Do they invest their own money? Is there somebody named Vanguard? Is there somebody named State Street? That's a very, right. State Street the fourth? No. They have human beings' money. Guess who's human being? Guess what human beings' monies they have? American workers. Why? Because to save for retirement in the U.S., you no longer get a pension. You used to get, if you worked for a company, when you retired, depending on the years you worked, how much you got paid, you would get X per month for the rest of your life. No, right now a company may give you some money that may match what you put in as part of your paycheck to money you give to a Vanguard, a State Street, and they control the money, Vanguard and State Street. You can't take it out or you get taxed at huge levels. So some of you are in your 20s, right? Some of you are teenagers, right?
It's a threat, right?
No, but what I'm saying is they have the money. And so in terms of the companies, who's voting the stock of the companies? It's Vanguard and State Street. And to Julia's question, how do you address this without law? Well, law created the demand for these money managers. There's no way to rationally save for retirement in the United States without giving your money to these folks. The law prevents you from getting the stock out effectively till you retire. You don't get the vote. When you invest in their funds, you don't get to say, my percentage, the percentage of votes that you issue that are attributable to Strine's money, that would not be very much. We don't pay judges that well in the year. I'm not complaining, but I don't have. But what money I have, what money my wife and I have is with Vanguard and Fidelity. We don't get to vote any of those shares in these companies. Vanguard and Fidelity determine that, Julia. And so my only point about this, and this is one of the debates that's going on, I think we mentioned Larry Fink of BlackRock. If you Google it, use your favorite search engine, you'll see there's a lot of discussion this about the responsibility of the institutional investors to the extent that they're exerting the power on the company to begin thinking in ways that are aligned with their human investors, right? As a human being, you don't benefit from companies that pollute the environment, that treat people poorly. You don't benefit if, as a taxpayer, you have to actually pay more taxes to take care of costs that companies should be doing themselves. And so there's a big discussion, Julian, right now about the mutual funds voting in a socially responsible way. But it's hard to divorce that from law because they've actually, frankly, we've created this industry largely by governmental policies and mandates on individual workers. So I think that we should be as market-oriented as possible. But remember, as we talked about yesterday, who's the fiduciary for most Americans, is why is it that the fiduciaries who just run actual companies would only have legal duties, whereas the fiduciaries who have everybody's money would not? So I think you've got to actually align the legal incentives along the way if you're going to do it with responsibility. I don't think you can just, how do you just say to Vanguard, do whatever you want? It's not their money.
Okay, but then it's not the corporate law issue.
It is a corporate law issue.
No.
It is for this reason, because we think about when we wrote these laws, no one knew what Vanguard was or State Street or 401k because it did not exist. There were assumptions behind the creation of law. Those assumptions, you should know them and their history, students. You should always respect the history, because the history of law, it's a deep thing because it's how human beings peaceably address problems. There's insight into that, right? When you go back 300 years, a lot of the problems aren't at their root very different, right? The problems of the incentives people have, right? If I can make money by being, and I can dump all the waste of my business on somebody else's property, right? That's a problem that has existed for hundreds of years, thousands of years in human society. It's just ExxonMobil's bigger than the cattle farmer next door, but it's the same problem. And so what I'm saying to you about the stockholder, we chose when we passed laws to assume things about stockholders and what their duties were because of what our assumptions about how things were about them. When who the stockholders are changes, what the practical power that they have, that's the duty of lawmakers in a society, in a free society, to adapt those principles to the current circumstances.
Okay, Leo, but this is an American subject.
It's not just an American subject, because I very much, when I went to the CVM, I was honored to go to the CVM yesterday. I believe exactly these kinds of situations are your society is going to confront. The extent to which activist investors, right, to the extent that you want activist investors to be able to act on Brazilian companies, the extent to which you want to have some autonomy for your companies, or for them, many nations right now in Europe, there's a, part of why they do protectionist is they don't want their companies to become McDonald's. And this has been true in the US. You know what the biggest American brewing company is? Anybody guess? Budweiser is a good answer. Guess who owns Budweiser? Brazilians. Budweiser is not an American brewing company. Americans like Brazilians love beer. Sam Adams, I believe, and Yingling, these are very small companies because most of the great American brewing companies have been acquired by someone else. So part of what you lose, and we have had in Delaware, even though we're a home of corporations, the corporations that matter the most to us, Julian, are the companies that do business within our borders. We had a bank called MBNA that did great things for our community. Got taken over by Bank of America. Been a gradual attrition of jobs. We want everyone that they have, but when you have a headquarters in your country or in your state, the CEO and the board invests in that community. Activism, the extent to which you wish to have activism, the balance, the gain sharing you want from between Brazilian companies, between their workforce and your stockholders, I don't believe that's an American-based discussion because it's Australasia has gone through this. There was a big thing in Canada. Canada blocked an acquisition in one of its provinces by an Australian-based company because they believed that that corporation was essential to the economic progress of that part of Canada.
Wait, just give me 3 minutes because I'm trying to ask you a question.
I'll give you 3 steps. That's a rock song. Give me
3 minutes, Leo. No, three.
He's already going to spend 10. So
Give me 3 steps was a Leonard Skinner song.
Can you give me 3 minutes? I just want to make the point to the end because otherwise, the 3 minutes I want is to say this.
Can one of the students set a clock? I think we should set a clock. And,
So you can set the clock. Okay. But you set now because I cannot start. Now.
Start, Julian, come on.
We have this.
You're using your own time.
It's gone. It's gone.
We have this wonderful, great professor which used to teach at this law school and whom all that met him love him, called Professor Alfredo Lamy. Filho, he once said one sentence in a presentation here at this university, already a very old man at that time, said, and we have to be very careful to treat a corporation as a moral entity because corporations are not moral entity, people are moral entities. So the way corporations evolved was a trial and error system throughout history, which made a very delicate and balanced system. That's what he said. Now, I'm not using his words, I will use my words. My concern is that I love corporate law, but corporate law, and I would like to quote Burley here, is about shareholders and directors and corporation. That's corporate law. If we want to save the environment, that's environmental law. If we want to give more rights to labor, that's labor law. And corporations, need to fulfill and obey and respect labor law, environmental law, and so forth. That's where society is going to say what matters to them. My problem is once you start giving directors and shareholders these other constituencies, these type of things, you are creating fiduciary duties in practical terms. Chico, stop, please. You are creating fiduciary duties in practical terms for, directors will have fiduciary duties to everyone. They will have it to creditors, they will have it to workers, they will have it to the community. That's in practical terms what you're doing, because you're going to say, look, directors, even if you are complying with environmental law, if you're complying with labor law, you also need to take into consideration this interest of these people, which are not under law.
Julian, I think what I understood from Leo, but his point is different. You're still going to comply with all these laws because your company must be a compliant company at all times. But in a case of an offer to take over that company, what I understand is benefit company who has this vow, a deep vow, which I like very much, is I may consider not the Revlon case, I may disregard the Revlon case, if in my fair judgment, I can see that there is a harm for the community and accepting this transaction for this company. And I guess
that is not my question.
But listen, when you do due diligence,
may, I'm talking shall. May I'm okay with.
I listen to you.
I'm talking shall, not may.
No, it's listen. Shall means that you have to comply with. Yeah. You don't have to put your money in that community, all the money of the company, all the profit. You need to comply. You need not to pollute. Is this different from any other company? No. Companies need not to pollute. The benefit company and a normal company. What it's saying to me, as I understand, that the board of directors in a merger, in a takeover, in a type of transaction like this, may disregard the price factor if it's within a reasonable amount, to say that the second bidder or the third bidder, they present a different gain for society. And in fact, this is in higher value than the just money, because it will not harm the society. And this, for economic terms, I have here Vinicius, has a huge value, because we cannot forget, Julian,
I'm
that
agreeing
what
with you.
the thing that characterizes us, is one thing that Leo has in excess: humanity. One thing that makes us different from any other animal is humanity. So I think I rest my case. I fully understand.
Chico,
And I don't think we should consider all of this. And in our law, we have a provision saying that the controlling shareholder must respect other constituents.
Chico, I fully agree with what you said, but that was not my question. My question is a different question. My question was based on this discussion, theoretical discussion, that will take out the may and include a shall. Okay, that's a theoretical discussion, because that's something that Leo was talking about in Europe. So I'm talking about something totally different. It's not may, it's shall. And my question is, how does a judge, because if you put this in law, you need to enforce it. It's a simple question. Leo is one of the best judges I met in my life. So I'm asking to one of the best judges I met in my life,
Okay, I'm going to answer.
how would you enforce
I'm going to
this?
answer the question, and I want to go to our friend in the audience. But in answer, I want to explain two things that's important to go on. The easy way is, remember what the business judgment rule does. It gives you space. You're acting as if the primary thing that this does is have a bunch of courts go in and tell people what to do.
That's what would happen in Google. Right? The courts are bad, but not that bad.
Okay, I'm happy to, if you want me to answer the question, I'm trying to answer the question. And I'm actually take a little issue with Chico in the sense that I think the purpose of the benefit corporation is to actually ask people not to go to the legal minimum. For example, in our society in the United States, the minimum wage is not what it should be. And you see companies going to a so-called living wage. I'm sure the same thing, there's a debate in Brazil about that. The point would be, we choose to go to a living wage. We choose to give our employees full-time hours. A lot of American corporations would give employees what I call full-time, part-time hours. Enough hours that made it very difficult to have another job, but where you wouldn't get other benefits of employment. We're giving everyone full-time hours. We're going to give them a living wage. Stockholder says, well, wait a minute, we want a higher dividend. This allows you to say, we have to do things by all constituencies. It gives them space to act. Environment. Do we want to go to the minimum? We're done as a world if we go to the environmental minimum. Done. Party down. Stop studying. Enjoy the next 10 years, but don't have children.
Dentists.
Well, don't have children, because they won't want to live in that world, right? The point is to give people a duty, and by giving people a duty, that duties matter. People try to do the right thing. I genuinely believe most people, we're not angels, we're not saints, but most of us are not evil, and we like to do the correct thing. And there is a power to the duty. Why I like the benefit thing is it's not just some power to duty, it actually, with the supermajority and with the things, there's an enforceability to it. And so I think it turns the needle in the right way. Now you ask, why within corporate law? Why don't we just leave the theoretical? Why don't we just leave it to labor law in the United States? Why don't we leave it to environmental law? Because the damn businesses, at the instance of our Supreme Court, are using their own money to tilt the process. They're spending money to lobby. We had companies that suppress, they were preparing to adjust their business plan over time to climate change. They knew that it was real, and they engaged in efforts to stifle public knowledge of it, to distort that. They're engaging in political spending, and the frustrations, here's the thing, societies create corporations. Societies can take them away. Societies decide that stockholders get to vote. Societies can also decide that other people get to vote. When corporate power distorts the political process, cuts the ability of our labor law to protect American workers, when our courts, our right-wing federal courts, strike down perfectly legitimate exercises of environmental regulation, when they strike down legislation. You ever heard of John McCain? John McCain's an American hero. He is not a Democrat. He wrote a bill called McCain-Feingold, which restricted the ability of corporations to spend money without stockholder consent. You know what? Corporations in the U.S. before Citizens United, Julian, they could spend, Microsoft could spend $5 billion on McCain. Well, but let me tell you a story. Amazon or Microsoft could spend $5 billion through a PAC if they wished, without legal restriction. It's a political action committee. Any corporation could start a political action committee, and they could spend as much as they want on independent expenditures. The only caveat was this: you couldn't spend the corporate treasury funds. You had to raise the money from the stockholders or from your employees. John Roberts and the gang struck down this law, and they let corporations spend political money without the authorization of the stockholders. No one invests in corporations. And this was a conservative idea in the 1960s. Conservatives, part of the Milton Friedman focus on stockholders was, we don't want those illegitimate corporate people spending our money on social purposes. But the pressures within company law, and this is also true in Europe, is when corporate power gets out of whack, when stockholder, and really money manager power gets out of whack, it makes it difficult to use tools outside of company law to do the job that they used to do. And so people are saying, wait a minute, who is actually exercising the voting power over public companies? It's not human beings. It's another class of fiduciaries. Whose money do they have? They have human beings. Maybe we need to look at company law and make sure those people, because they're a different kind of stockholder than they used to exist, that they actually have to act as a proper fiduciary too, that they actually have to act and take into account the real interests of human beings. And honestly, if the corporations are going to act on society in a way that makes it difficult to pass labor laws, environmental laws, and other things, then we may have to adjust the power relations within the corporation. And so I'm not saying it's right or wrong. I'm saying it's freaking naive to think, to claim, I always call the U.S. thing, I say you can't just call ball. Like corporations couldn't call, we call limited liability, right? Can you imagine, would you go into the playground of life and say, I call limited liability. I'm a corporation. You can't do anything to me. I can do whatever you want. We call it calling ball, like you're a kid who brings the soccer ball. You can call when the game's over, your team's ahead 4-3. Mom says I have to go home, right? Well, you're trying to call ball for the elites. And the problem is for the elites now have to face the accountability discussion about the outcomes. I don't want to kill market dynamism. I think for-profit companies have to make profits, but externalities that are not something that we should encourage. And I don't think that the social compact will hold. if we continue to have the growing inequality that we have. That won't be good for us to include more and more people in the blessings of the world. I actually think it'll be disastrous.
Wait. Microphone. What is first of you?
Hello. I think that there is I think the three of you are making discussions, and I think one fundamental point to be raised here is that the level of development and the way going forward, what I think Julian and Julian is a speaker of free market and self-regulation. I think his concern is the application of these laws, and when you use the business judgment rule and how judges, how they interpret the business judgment rule, and his concern is how they will interpret, and that is a concern of, I think, a lot of people, just because, yes, possibly some of the judges do not know. But right now, I think I'm not sure whether you have heard this or not, but the courts in the state of Rio are discussing whether they're going to have specialized chambers in commercial law. So,
Chamber is specialized, but the judges are not.
yeah. So I'm not saying that I'm for or against it, but if it does happen, and I think what judges need to go through is they need to become experts. They need to understand the issues. But at the end of the day, I think when you talk about interpretation and business judgment rule, it's not only applying the law, but understanding the issues and having the experience of having been in a company, of understanding. Because every time I hear the discussions on business judgment rule and some of the applications that I've seen, what one of the issues is you either have a judge that has an experience in companies, and they don't want to be the Monday morning. They don't want to be they don't want, sometimes you have judges that want to be as you say, the Monday morning quarterback. And the problem is you either understand the issues and you've been trained with the issues. So I'm talking about capacitation of judges. That's what I'm talking about. When you have CVM, for example, Gustavo here, which is next to us, I know for a fact that he has experience in interpreting the business judgment rule. Not only in looking at the law, but understanding what this means in terms of running a company. And when you talk about the application of the business judgment rule, it's not only a matter of understanding the law, but understanding how to run a company and the decisions that are made in that split second, and not wanting to just review that post factum, because it's always, hindsight is always 20/20. So I think when we're talking about the levels of development of the law and of the culture and interpretation of the law. And your level right now in the Court of Delaware, for its tradition, it's in a different level than in Brazil, but we have to move in that direction. I think that the answer is we have to move in that direction, try to develop it, and we have to try to apply. Our law already has responsibilities for controlling shareholders. In the spill, in relation to the environment, it has responsibilities.
But it only applies to the controlling shareholder.
But so we have to move in that direction. We have to have these concepts, but we have to change the culture, and it requires training of judges, of justices, but we have to move in that direction. The problem is right now, Brazil, it's like a frog. It stays there sitting down, and suddenly it jumps. And now we have a government that is liberal. The frog jumped like 200 yards, and we are moving. A big frog moved 200 yards. But I understand, and I think both of you are saying the same thing. It's just different moments in terms of development, not only of the law, but the culture of the application of the law. And when we talk about judges, we talk about judges in the court of law, but at the end of the day, as we discussed before, the judges are the folks at CVM that have the understanding, and not only of the law, but how the law is supposed to be interpreted in a company, in running a company. So the consequences of making decisions to the day-to-day. So I think we're all talking about the same things. It's just different levels of development. We mentioned the UK and the board in the UK. The board in the Carta Magna has 806 years. So that culture is already there. It's been there for 800 years. We in Brazil, our experience with board is 20, 30 years.
But that's why I mean, I think one, it's always important to look to try to anticipate
Yes.
a little bit
Yes.
about where you're going to go,
Yes.
because I think to be honest, one of the things you're trying to achieve, and this is no insult to founding families or controlled companies, you hope you have a dynamic nation that's has great economic capacity and great promise. And if you can begin to extend the, frankly, the kind of access to that kind of education that you all are getting to other people, you're going to grow enormously, and you're going to have companies that don't have an old-fashioned controlling stockholder. You're going to have to wrestle. An interesting case to actually teach your students is the case about Elon Musk. There's a new case about Elon Musk. He doesn't have come close to having a percentage of voting interest that would be alone, but the Court of Chancery, I think, quite appropriately found that when you look at how he set up his companies, he effectively was controlled. I think you have to look ahead. And you're talking about adjudicative capacity. Again, don't be so hard on yourself. One of the nightmares that Delaware companies face is when they get sued in another state. You go to a judge in Illinois. Illinois is a big state. They get a corporate law case. Judge doesn't know anything about corporate law. The judge does sophisticated criminal law every day. He's doing contract law, doing regulatory law, doing family law.
And it's not fair to expect that he will have that.
Okay, and that's what I'm saying.
It is fair.
Well, no, but
It's fair.
it's fair in this way, and this is something we've talked about over the last couple of days, students. And I would have given you a listening device, and you could have listened in if you needed sleep. But one of the things we were talking about is I think you're really right now quite unfair to your judges for this reason. Some of the most sophisticated lawyers in the country deliver decisions in corporate law cases all the time, and the judges don't get to read them because you have arbitration under the Novo Mercata. It's in public companies now, but the tradition of private rulings was because arbitration was not in the court. It was about private parties. One evolutionary move that could help inspire confidence in Brazil, help those judges, would be to say, yeah, we're going to continue with the arbitration because, frankly, we don't provide enough adjudicative resources for ordinary people, and it's very difficult necessarily to have enough. Let's decide we're going to have a court for the haves, right? And this isn't even a question about just of ordinary people. This is a question about within the business community. I bet you have a lot of small and medium-sized businesses who say, frankly, we have contract disputes, other sorts of things, regulatory disputes with the government. We'd like them to move faster. So I understand it. It's controversial in the United States. A lot of American court states have the same trouble, which is how do we create a court that's for the haves? Retain the flexibility, the speed, the ability to get expertise of arbitration, but make the decisions public. Allow for the body of learning. You don't have to make a binding precedent. Frankly, then if you're a judge, what do you do? If you're in Chicago and you have a Delaware law case, right? What do you do if you're a good judge? Students? Right? You read. You get your staff and you read. In Brazil, if I'm a judge, the most of the body of all, I can look at Gustavo and the CVM, what they've done, but you know what I can't look at? No, let me finish. You cannot look, students. When the stockholders have sued about a breach of fiduciary duties under the Brazilian corporate law, can you as a judge, and you're in the Rio court, can you actually read those decisions? Can you read those decisions, students? You cannot.
I just wanted to mention a point on what Chico said. I agree with what Chico says in terms of the knowledge and experience of judges in relation to sophisticated corporate issues and capital market issues. I couldn't agree more. Mainly, not only because they're not specialized, but because they don't get the cases for these two reasons. But if we take the example of the Court of São Paulo, which is a specialized court, I'm not going to talk about the business issues, but if you look at the rulings that they are rendering in insolvency, where they see the issues every day, and you see the professors in law that are judges and are doctors in USP, in PUC, they are writing very sophisticated, in Rio also, Ayubi, Massacuña, yes. So what these specialized courts in São Paulo are doing in the area of insolvency, and not right now insolvency is not only what it used to be before the new law. Now insolvency deals with turnaround, with financing. These judges have a very good grasp at sophisticated business issues that they are dealing with.
My point is that you cannot know anticrese, usufruto, execução, inventário, locação. It's impossible.
Exactly.
It's impossible.
So what
It's
I think
impossible.
what I think you're saying is that they have to be really specialized, not only specialized courts, but specialized judges. That's what you're saying. Because if you have specialized courts and specialized judges, you will always have the opportunity to either go to arbitration, if need be, you go to a court. And when you have to go to a court for a provisional measure, that judge needs to know what he's talking about.
Yeah, and all I'm saying is it's really hard for a judge you're expecting to be a good generalist when he can't read, when there have been 150 arbitration decisions issued in the last 10 years by sophisticated folks. It would be kind of good if that judge was able to read them. And if you make that adjustment, I think you'll be investing in the capacity of judiciary. Realize this is a struggle in the United States. It's a struggle everywhere. And we struggle with the balance between general courts and specialized courts. And I don't think this is at all unique to Brazil. I think that actually, as the world has become more specialized in the US, we are actually struggling with it quite a bit about intellectual property. Our intellectual property court of appeals at the national level is quite controversial, and people don't necessarily think it's doing a good job. And it's a balance to strike. But I do believe that unless you spread learning and allow there to be accountability to the rulings, right? Wouldn't it be nice for you as students to actually see some of these arbitration rulings? Yeah, and so I just think that that's a natural kind of extension. I think it would also promote confidence in the system. I think you get more accountable rulings as well. When people look, one of the things when you're a judge and you got to have your name on something, or if you're a regular, you have your name on something, you think about that, right?
I'm just saying, we can all sit here and say, look, the courts, they're not specialized, they're not prepared, and I agree with that. But we have to go to them for provisional measures. So we, as the holder of this culture, of this knowledge, if we don't interact with them and we don't try to help, when we go to them, they don't understand. I'm not criticizing.
They could do that on their own will, right? If you believe you are not prepared, if you believe you are not fit, you study on your own. You try to be better.
Some of them do. Some of them do. But they welcome every time. Chico, if you go to the courthouse and you want to make a presentation, they're going to welcome that. You know that. They're going to love it. Any one of us here, they're eager to understand that.
I prefer to listen to Fábio Coelho.
Let's go to João Pedro.
Because Fábio Coelho goes there.
Nobody invited me yet.
I'll invite him.
Two small contributions. One is a statement, and Caio is over there to contribute also, because there is a story on academic theory here in Brazil that normally when you conduct like empirical studies to support your arguments, it makes your argument much better, So there is a study that was done in the US by Vanessa Finch. I don't know if you remember that, insolvency law. We did the doctorate degree together. And then there is a discussion on the ability of Delaware courts to end up on successful Chapter 11 cases. And the reason why it happens has a lot to do with the ability of judges to fully understand the discussion and only the Chapter 11 law, but go into details of the corporate resolutions being taken, the reorganization and things like that. This is just the contribution I would like to read. And then there's a question. Chico was saying something very interesting regarding Brazilian law, because in Brazil, we do have a different system in which, like, all those protections for social function, employees, stakeholders, and so on, all of them are taken care by the controlling shareholder. There is a specific provision for that in the Brazilian corporations law, which is Article 116, chapter, okay? There is a discussion that for the enforceability of these protections against the controlling shareholder, there should be a specific corporate, let's say, action, a suit, available for the stakeholders, available for the employees, available for the workers, or things like that, so that they can enforce this provision. Because it only have like from the minority shareholders against the controlling shareholders. I would like to hear your experience on that and if this makes sense. And also to contribute, and my teacher and my
No, I think there is
maker.
There is a debate about that, and the benefit corporation.
Teu pai?
Yes, and also here, my scammer.
I'm not going to get into that. And there is a debate about that, which is, again, relates to this question of, if you're not aligning power with purpose, how do you get anything? The benefit corporation model assumed it took a conservative stance. And so I think you do have to be a stockholder to sue. But the assumption was that there might be socially responsible funds or others who were within the constituency. For example, many companies in the United States incentivize their workforce with equity. We don't have a minimum holding requirement to bring suit. So if you imagine a bunch of the employees at a company that had been given, as part of their compensation, stock, they could sue under the provision. They would be suing using the stakeholder provision, in the sense to enforce the stakeholder provision, but they would have standing as a stockholder. So we've grappled with that. I mean, I'm saying it's a legitimate point, but we're in an evolutionary mode, and there was a conservative approach taken that it's still a stockholder-based thing, but it shifts power if there are some stockholders, again, who are socially responsible, or the workforce, or frankly, there's a union pension fund, then they would have standing. What I'm confused about is, if you have no controlling stockholder, don't the people who govern the corporation have the same duty? Well, that's wrong. And again, that's not looking around, that's not looking forward, because that creates a gap where only if a company is like, a company just has a management team and doesn't have a controlling stockholder.
Yes. And also our structure was all made
Which
in
is
the
why
idea of the concentrated ownership structure.
Did you hear that again? Did you hear that again, by the way? Keep that in mind. This was written in 1976 when all companies had controlling stockholders, which is when you were told yesterday, when you think about your company law and it being shareholder focused, it doesn't mean, do not confuse it if you get comparative readings in the US. It would be because what this really means is that the people who had control could act without worrying about, it was the controlling shareholder power, controlling shareholder centric. I'm just saying that's the one thing we always have to do is adapt, right? If all of the corporations are...
You don't have minority control either.
Well, no, and that's what I'm saying is, if we want all corporations to act with due respect to the other constituencies, then whoever is the governing them, whether there's a controlling stockholder or not, should have the same obligation.
We should now try to get some students to ask questions, because so far only professors have asked questions.
Professors, I guess, I know. The professors are important because they also bring light to the
course,
students.
no, I'm not complaining. I'm just saying we should try to get some students.
Pessoal, muito fácil de ter muita conferência, não.
Good morning. My problem with this discussion is that, imagine the situation with two companies. and there's an offer. And then the higher bid is from a company that respect workers' rights, slavery. So what this second company is doing is crimes, committing crimes. And the function to judge and punish crimes is from the government. When the government transfer this responsibility to all the directors of companies, it's just like if they were saying, okay, it's a crime, this company is disrespecting workers' rights, but I'm transferring my responsibility to judge to all other directors. And I assume that I can stop these crimes, I can punish in the correct way. So now everybody, every director is responsible to not negotiate or not sell to these companies that are committing crimes. So it's a kind of economic blocking this company because the government that has the function to judge and to punish and to stop this crime is not, they are not.
Well, I agree. Look, but remember, there's also not everything. There are many nations in which there is conduct that would be a crime in Brazil or would not, put it away, not even, there's a difference between criminal law and civil law, but will it be illegal in Brazil or in the United States? That's not illegal there. To be honest, I'm a big soccer fan. FIFA won, it corruptly gave the World Cup to Qatar, but take a look at how those stadiums are being built, right? A lot of conduct, I don't know that is the Qatari government, I don't know what it means to be a crime there, right? What we're talking about here is we can't confuse, it doesn't excuse government from its ability to enforce law. The point is your duty. I'm a company, you all are workers today. We're the board. The bidder, I'm going to stick to my thing. The bidder at 44, it's the high bidder. When they bought operations in Europe and in other parts of Brazil and in the United States, the first thing they did was to shift the production to parts of the world where there was no fair labor protection, where there's no maximum hour working things, and where there's child labor. May not have been illegal in those countries. Wasn't necessarily illegal for them to close down the plants, but that's what they do. They've been the subject of environmental enforcement. They're not been barred from operating. They paid fines. Do we have to face the moral mirror test? Don't externalize it to government. We can get 45 bucks, 44 bucks, and you're all our workers. We can take that bid, or we take 41.50. 41.50 is still a good price. We've looked at our DCF model. The reality is we got execution risk. We've got some challenges in the industry, but the 41.50 bidder, we look at them. We look at how we treat you. They treat their workers really well. They have a good reputation in their community. We think that they're a responsible buyer. They're actually willing to make commitments to keep the workforce open. We may own 20% of the stock collectively. Question is, can we make the moral judgment? And one on the benefit corporation is we actually have a duty to look at all of you as our workforce as we make this decision, and to consider whether this is consistent with your best interests. And that's the point.
Can you have this in terms of for controlling shareholders? That would be a good solution.
We have, see, and this is where I think, again, we got to get principled. Whoever the fiduciaries are who are exercising control of the corporation, remember, if there is no controlling stockholder, does the corporation not operate? Is it out of control? Or is it in the control of whoever is the board of directors and the executives the board of directors select? So under our law, Julian, whoever is in control, the only reason we impose fiduciary duties on the controlling stockholders is what we call in the US, it's a Latin, tautology, right? When something defines itself. The reason there's fiduciary duties on a controlling stockholder is because the controlling stockholder has students control of the corporation. The reason you typically don't impose fiduciary duties on a stockholder is typically they do not have control of the corporation. We would never conceive that a director of a company who's on the board and is voting to make corporate decisions would not have fiduciary responsibilities. Well, that's what I'm saying. So it wouldn't vary by whether you have a controlling stockholder. It makes no sense to me, because otherwise it assumes there's companies out of control, and then there's companies under control.
Can you apply business judgment rule to the way the controlling shareholders act? But I always assume that you cannot. It's only direct.
If the controlling stockholder is not acting in a way that involves a conflict of interest between anyone else, then yes.
Yes. Okay.
On most
That will
questions,
not be the case.
a controlling stockholder has no conflict of interest with the other stockholders, the employees. Like if you work for a company, do you want the next product? Do you want the product you're making to suck? Well, no, to not sell. Do you want to make a product that no one buys? No, that's what. But mergers, Gustavo. Why I use a sale of students is one of the areas where we've said that you can't just act alone. That's where you actually have to get stockholder approval. That's one of the classic ones, or amending the corporate constitution, which would be the charter. You have to get
But this, for example, amending corporate charter would be a business decision.
No, because the charter. Well, the way we combine Republican democracy and directocracy, because the stockholders are not allowed to propose a charter change. They're not allowed to propose it. The board has to propose it, but the board can't implement it. The board has to get stockholder approval. So we do have voting, but it's, again, mostly comes from the proposal of the board. If you really want to change policy, you have to elect a new board. But you do get to protect yourself by voting down things like a merger or a charter change.
So just to piggyback.
In what case?
In a case where shareholders are voting something.
A business decision, just to piggyback on Julian, if I understand correctly, in a business decision taken by the controlling shareholder, the business judgment rule doctrine. But the business decision that's taken, you can actually use the business judgment rule doctrine as a defense.
Again, I would give the classic example. We want to. No, we want to do a new product. We've rolled out a new product. It does not succeed. It costs money and someone sues, and you have a controlling stockholder. Would the controlling stockholder and the other directors get business judgment rule protection? Sure. If a charter change, you have 57% of the vote yourself. You have your board propose the charter change. You use your voting power. It benefits you at the detriment of everyone else. The vote would not give you business judgment rule because you would have been using your own power. That's why students, we said, if however I said, we will only do that charter amendment. I will only do that charter amendment not only if I approve it as a stockholder, but if a majority of the minority does, then you can get business judgment rule. Do you get me on that, students? Which is I got 57% of the vote, right? If I vote through the charter amendment and it benefits me, I'm conflicted. If I say I think this is good for everyone, we will not go forward with this. Not only unless it's approved by you. You own the 43%. Unless a majority of you approve it. If a majority of you approve it, then we will do it. And it relates to your other question about dispute resolution in Brazil. The more you can use structures that ensure fairness, right? Like if you're the minority stockholders, you get to protect yourself. You get full information. I think that lessens the pressure on the dispute resolution processes while still ensuring confidence and fairness. And that's the way we try to do it, because we're trying to avoid judges getting into the actual details of policy. So if the minority stockholders get the chance to say yes or no for themselves and they get fully informed, then we don't get into these questions. Because I mean, I like to think after 20 some years, I'm a pretty good judge. I don't make products. You know, I mean, I guess unless you call judicial decisions products, in which case I don't get a very good rate.
Okay, Kyle, I think has the last. Yes. Okay, I have time for one more question if Kyle wants to.
Just one more? Okay.
We have time for more than one, I don't know.
I'd like to do two, in fact.
Yeah, we have more than.
Okay, Kyle, you get.
Okay, one about corporate law. Professor Strine, Professors Zohar and Sharon has just published a paper called The Death of Corporate Law, where they argue that more competent shareholders become the less important corporate law will be. And they argue about the importance of Delaware court. What's your view on that, please?
What they call the death of corporate law, I would call the success of corporate law. Well, you're law students, right? Imagine you had a problem. Like you had a situation that you didn't want to occur. And so someone did something, harmed other people. You have a case that addresses it. Folks react to the decision and they don't harm other people in the same way again. Is that the death of law or the success of law? Zohar, I like a lot, but his premise is this. The Delaware courts have put in place guidance for people who are business fiduciaries. And if you follow that guidance, then there isn't really a lot to write about. And because there's less of the same cases all the time, our law has died. That makes no freaking sense to me. Wouldn't it be the death of this common sense to assume that we have the case? I said there's a Bill Murray movie. There's a Bill Murray movie called Groundhog Day, where every single day is the same. Well, you see, you have the case where somebody gets harmed. The judge, the way you react to it is every single day you wake up, there's another case where the same thing happens. That's when law is idiotic, right? The success of law is not to encourage the repetition of socially suboptimal behavior. The purpose of law is to actually address wrongdoing, but to address it in a way that also provides guidance to folks so that they don't engage in the same behavior. And I think Zohar's saying is we've actually spent a lot of time, and I think it goes to your point, trying to create incentive systems so that boards of directors can act in a way that is with high integrity, get things done in a way that where the minority stockholders and other people are able to protect themselves with a minimum of litigation cost and things like that. So, I mean, I just don't, and I told Zohar, a friend of mine, this article makes no sense to me.
Thank you. And
no, it's like if Barcelona reacts to the winning goal by Liverpool by continuing to not pay attention on corner kicks. In his role, he would say then that's the success of Barcelona. If they give up 20 more goals like that in the next 3 years, Zohar would say that's really cool because I'm a professional soccer commentator. And one of the things about professors, Kaio, is and students will tell you, professors like to write about stuff. They like to talk about stuff. And so goof nut situations, which may not be very fun for the actual participants, are great if you're a classroom teacher. It's actually good if you're a student. Like, that's really cool to read about, what BP did.
What polar bears do in the summer, or
Or what BP did to the Gulf of Mexico. Let's have them do it every year if I'm teaching environmental law. But Kai, you had one more.
Yes, about arbitration. I would like to know, Professor Strine, how the Delaware Supreme Court deals with arbitration clause inserted into the bylaws. Does it apply to management that is not part of the bylaws?
Go over that again. Does
there's a provision in the bylaws of a given company in Delaware, and then this provision, because it's not signed by the officers and board members when they take office, does this provision that is in the bylaw apply to disputes?
Yes.
Including directors.
Well, I mean, this has become an evolving thing, but
And I'm sorry, just in addition, if you could give us a view of how the Delaware court faces the arbitration there in the companies. Bylaws.
Well, when it's a matter of so-called internal affairs, and this is actually a matter of some controversy, but what we mean by internal affairs is the relationship of the stockholders and the managers of the company under our corporate law, which writ large, which includes as we talked about yesterday, the code-based law and the fiduciary duties. Then you're assumed when you buy your shares you buy your shares, that the certificate says, what the bylaw says. If you choose to serve as an officer or director, you know that. And so to the extent it says that the dispute resolution, arbitration, though, is not something we use in public companies or in Delaware corporations. And if it's a widely held company, it's not. Yeah, but forum selection bylaws, because our law actually presupposes litigation. But an analogous thing is where you have to sue. And it's become common because companies were getting sued in 4 or 5 states to have a Delaware forum selection. And that binds folks. Arbitration in the US, and where it's very common, is two companies choosing to enter into a joint venture and have the disputes resolved by arbitration. Even in merger agreements, there are sometimes students, when you close a merger, shifting of risk, responsibilities for certain types of tax claims or other things. Often the two companies will agree on arbitration. One of the things we struggle with, which you probably do too, is, especially in the US where it's not presumed you go to arbitration, is you only go to arbitration when you spell it out. And then there are sometimes divides about how much authority the arbitrator has to do certain things. For example, it was not traditional in the US for arbitrators to have so-called injunction authority, the ability to actually stop something or order specific performance. They could only award damages. And so there's been a move towards saying that essentially arbitrators can do essentially any type of remedy, but that's a product of agreement. There was then questions about whether they could supervise the evidence discovery process or you had to go to court for that. Increasingly, parties have been trying to negotiate so that the arbitrator can do everything. And then there was this question. If it was unclear whether you had to arbitrate or not, who decides, the arbitrator or the court? And so that's been and that could cause a lot of delay, right? Because a lot of times in commercial disputes, one party wants it to go slow, one party wants it to go fast. And so it's a complex subject, but increasingly people have been moving towards that the arbitrator you select will also decide on arbitrability.
Yes.
That they will actually also decide on the evidence gathering, and that they have the ability to give either injunctive relief or monetary relief. But this is a negotiated thing. And then, of course, you got the whole confirmation process, which is one of the issues, and I think it's probably true here, is in order to actually enforce your judgment in arbitration, if the party resists, you often have to go to court. And so it can be quite time-consuming even in the States if you don't do it right.
Would it be lawful for a public corporation in Delaware, for a public corporation in the United States to have would it be lawful
for a public corporation in the US, I know that's not the tradition, But would it be legal to have an arbitration clause in the bylaws?
Julia, can I make my questions together? I think they go together because I'm not an arbitration guy, but you know that arbitration is a big issue nowadays in my mind. No, my arbitration guy is 3 chairs to my left. But I understood that the Supreme Court, the U.S. Supreme Court, they issued some recent decisions about consumer and then employment issues that they. I understood that they are saying in a certain way that arbitration is not suit, and I think they are right. They say that it's not the best tool for class issues. And
okay, students. Think about your working.
You're talking about Delaware, right?
No, this is. I mean, it's a. I think Gustavo, if you want to read a decision that will help explain social divisiveness, read that one. You get these form contracts, right? Students, how many times have you signed up for a website? And you check that box to read the terms and conditions, right? You read any of those things?
I usually read a little bit.
I was talking to the students.
But I just look at it to see this.
You know what's in all of those, right? You know all of those have an arbitration provision in them. You know when you get a credit card, they all have an arbitration provision in them. Do you really have any negotiating authority over that? Well, in the U.S., I got to tell you, it's not illegal. And employers in that case, and here's it's an amazing case, not in a good way. The U.S. Supreme Court has allowed, there's a thing in contract law, we call it adhesion contracts, where you don't really have a thing. Right? Our U.S. Supreme Court has basically said adhesion contracts are fine against low people. Companies can make that worker in that case was made to arbitrate. And the Supreme Court, if that worker said, I didn't really have any choice, they would have said, no, Federal Arbitration Act says contractual freedom. So he had to arbitrate. So here's what he does. I have to arbitrate my claim. My fellow workers are similarly situated. I want to bring a class action. The employer said, oh, we didn't agree to class action. We make you all arbitrate, but we don't say you get a class action. The federal courts had always said this contract is a law, a state law, not national law. You apply contract principles. Who drafted the contract? The employer. If a contract is ambiguous, it's unclear, students, it could have 1 of 2 reasonable readings. If there was no negotiation and you drafted it, it's interpreted against you. That's U.S. law. And what did they hold? The employer made the employee arbitrate. So the employee, if there was no arbitration clause, the employee could have gone to court. So the employee had to arbitrate. The employee says, fine, I'll do a class action. Wins under traditional contract principles. And here gets the thing about confusing as heck, right? I've just told you our Supreme Court said arbitration, we love it. We let the haves impose the arbitration. Really, they actually say any doubt should be resolved in favor of arbitration. Who wins, students? The employer. John Roberts says if there's any arbitration is a matter of choice. It's not clear that when the employer was putting the thumb down on the worker, that it meant that you could bring a class action. And yes, we understand under state law, but the FAA actually in this narrow thing, and there's actually a footnote by Justice Thomas that makes no sense, where he basically says, yeah, I kind of agree that the right party won. I'm for the haves versus the have-nots. Put aside all my case law, even though I respect state law principles of contract interpretation. The dissent says, hey, Clarence, what's that mean? Clarence Thomas is a really bright guy. He knows what it means. I voted to put the thumb down on the worker. So no, that's not cool at all. It's not law, students, it's power. And when you exercise power in a way that you wouldn't apply equally to other similarly situated people, then it creates disrespect for the judiciary. And when you have lifetime tenure and you can do this to people, and by the way, Julian, then you ask, why is there pressure on company law? Why do people want to start having power within the company? Because he had a right under our default law to have a class action. The employer has now made him go into arbitration. He's accepting that, but he wants to represent everyone else. He wins under the traditional interpretation of law, and our Supreme Court says no. Yeah, but when you have a life tenure and you would poison on a whole society, and this is what happened with the political decision of striking down McCain-Feingold, when you distort the normal operation of things, what are people supposed to do? Just lay down and take it? They're going to figure out leverage points. And so this is a decision, in my view, that's created, it's just yet another, and I could go through this, is of decision-making that's very difficult as anyone who's a professor of jurisprudence to explain as the application of neutral principles. It looks like a series of votes on various issues where they pick the class of society, the side of an interest that they wish to win, and they decided on that basis. And when the principles that they apply in that case don't apply, don't fit easily, they just ignore it.
My question about bylaws, if you can include in the Delaware law arbitration provision in the bylaws, would that be binding and take it out from your courts?
I think I do not believe, part of why we have difficulty with this is the FAA says you cannot discriminate against arbitration contracts. We are a very pro-arbitration state. But to be honest, we don't believe arbitration fits with company law unless the stockholders all sign the agreement. Yes, we think a close company, if there are 3 stockholders and they want to do it this way, that's probably fine. It is not the model of our law, and we don't like it. And we think it's a distortion of the accountability function, and it goes back to our discussion about the public nature of decisions as well. We believe that, you got a public company, you got dispersed stockholders. The ruling has to bind everyone. There should be a public adjudication. We actually think that's most meaningful, to be honest, when the directors, when the people who run the company win, it's actually most beneficial that that be done in a public way so that it inspires confidence. When you when the stockholders just know that they lost, but they don't know why, that's the kind of thing that promotes conspiracy theories, that thinks that it's just a rigged game. And so we're very much in Delaware not in favor of this. And remember, our Court of Chancery works fast. That's our brand. You're not getting anything out of arbitration. It's actually slower. Because remember, if you want to enforce the judgment, you have to go back to court. There are all the things Caio raised about fighting. If you go to the Court of Chancery, you know the judge is going to handle the discovery. You know you have jurisdiction. You know that you'll get a direct appeal and it'll go fast, and your judgment will be enforced. So I don't really understand in a Delaware company what it is, except if the managers are actually trying to tilt the game for themselves.
Just one question about confidentiality. The public nature of the decisions are very important, but in Brazil we are going, I think, in the wrong direction. We have many arbitral tribunals. As Chico said, we have specialized courts, but not specialized judges, which unfortunately is true. So it's an achievement in Brazil to have arbitration in corporate discussions, but we don't have a case law anymore. We don't know how the corporate law has been interpreted.
But what I'm saying is that's a false choice, is you can use the benefits of arbitration. There's no reason you can't continue with arbitration with the expertise, but then make the decisions public. Then you get the best of both worlds. You don't need even to make, and you know this, you don't need to make it binding. Binding precedent is useful, but it's also rigid. The reality is the weight of the decisional law, the things that work, will start to win out. There'll be a discussion about it. So I think arbitration is a perfect fit for where Brazil is in its adjudicative move. I just think that the category error is it's private because it's not private anymore. You're using arbitration. In many ways, you're using arbitration to get the benefits of an expert business court. And the public law is dictating the use of the arbitration. And given that it's also creating the market so that these folks get paid, that it seems to me a really simple kind of, and nothing simple, but if you talk about huge amounts of gain at very no cost, just changing this so you get that body of guidance. And then to the extent that you do have to go to a generalist judge, which again happens in the US, instead of us making, blaming the generalist judge, you could actually blame them fairly. I mean, imagine if after 5 years you've had all the arbitration decisions out there and there's a body of law. That also means the lawyers can directly cite it, right? I mean, that's the other thing is they can't even give the judge input. So then if you have to do this for 5 years and you have the CVM decisions plus the arbitration decisions, even if it's a generalist judge, if you assume the judge has to spend, it's a big case, has to spend 40 hours on the case, then that judge should have to spend 40 hours reading this stuff. Right now, that's not there. So that's all I'm saying is I think it's, and don't be so hard on your judges and everybody else. It's very difficult to know every single thing in the world.
So under the U.S. law, it's not possible to have a confidential arbitration.
Oh, yes, it is. It always is. But see, that's what I'm saying. It's a category error.
We have been discussing in Brazil.
Well, what I'm saying is, see, under here. Here's what's different. What I'm saying on the tradition of American law, the tradition of arbitration is that you have some dispute that could otherwise be in the courts. In the U.S., our courts have to be public unless there's some really thing like the Colonel's secret recipe, KFC, which I love. You can't get the recipe in court. They can keep that secret. But otherwise, I actually had a fight between the Colonel and their distributors. What you could do is if you have a business and you have a case that's otherwise would go to court, you could agree to resolve your dispute through arbitration because it was just between your two companies and assume there was no other disclosure. Like sometimes the resolution of a case requires a disclosure on the environmental laws or something like that, but there's no other reason. It's just a disclosure. You've been long-term business partners. You had this fight. You couldn't resolve it, but you want to have the fight. But frankly, you don't want to have a public fight. You want your relationship to continue. The idea in arbitration is that was like a neighborhood dispute being solved. Because you didn't use public adjudicative resources, there was no basis to require it to be public. And in many of the reasons why you did it was we actually wanted to keep our fight from everybody else. The difference in Brazil is under the Novo Mercado, it requires arbitration in entities that are public. So the government it's a way of marshaling expertise and speed in a society where you can't allocate to create a business court. And so the category error is that the privacy notion that exists just doesn't apply. And so if you just sort of tweaked it, you get all the benefits of the speed of the expertise, but then you take away the oddment, which is public stockholders are being bound by something and they're getting told the result, but they're not actually being told why. No one at the court or the CVM gets to read. I don't know the CVM gets to read these things. No. So nobody is learning.
But in Brazil, the arbitration is only between the two parties. You don't have the effect of the whole class being affected.
Doesn't it affect all stockholders?
No.
Indirectly.
You're talking about, for example, a dividend. A dividend. You paid less than you wanted. I want more dividend. You pay for my shares.
But doesn't everybody else get the dividend increase if you win?
It may, if it's a question of dividend. But if it's a question,
it's very confusing. And to change,
We don't have class action, so it's not derivative either.
But Chico, and look, these students. And I think we need to be mindful of humanity, which is where we need to end this, right? Let me just tell you that the more.
Ele está falando da ação da arbitragem do Carvalho.
Do you ever watch American television, like when the talking head shows? And it says Chris Matthews and Joe Scarborough in Portuguese. Okay. Let me just I would actually argue this. One of the things we have problems with when you do class actions, right, is whether the people representing the class are really representing the whole class. We've also had problems in the U.S. of some of the activist hedge funds coming in and using remedies and not sharing. The remedies don't go to the other stockholders. In a public company context, I actually think, to the extent, Chico, that there's what we call rent seeking for some of the economic students, someone seeking something for themselves but not necessarily for everyone else. It's actually more important that it be public, because if there's the potential for that, it still affects everyone else. And so I think even if it doesn't, I think my point is that you're using a remedy, you're using remedies that are statutory, right? Because your fiduciary duties, like ours, really emerge out of the statute. It's a public company. You can't have two, you can't say the dividend was valid or invalid. One ruling is valid, another is.
That's the problem with arbitration.
But that could
Well, but what I'm saying is it shouldn't. And what I mean is it's going to have collateral consequences for all the other folks. And if you want to make sure that the people are not using the tools that belong to the many for the few, then exposing that, making sure the rulings are public, holds everybody honest. It creates really good incentives. And you've got, look at these students. These students have stayed despite all kinds of biological and other reasons to wish to leave. But with their dedication to learning, they would actually read this stuff. And I think we should applaud the students for their willingness to listen.
Leo, two last things before I pass to Chico and Professor Pedro Paulo to finalize. One is very unfortunately, we need the companies that are already in Novo Mercado to agree to change the regulation so that it become public, which is very unlikely to happen. But it's a very good idea, and we should try and pursue it. The last thing is, from all I heard today, I think we have a very simple solution to all our corporate law matters, which would be the following. We could include in our bylaws a provision saying we need to get the case resolved by Leo Strine. He doesn't have to follow the law. He can only do an equity, and whatever he decides will be fair and just. I would happily recommend this to a client. Unfortunately, as we don't have only Mr. Leo Strine as judge in our cases, we have to look for more creative solutions. But this is a solution I would happily have.
Julian, thank you very much. I mean, before I pass on to Professor Pedro Paulo to end up this amazing session, I would like to say again what always astonished me in my relationship with Leo is his humanity. It is his ability to look into problems with a heart, generous and giving. So this is a corporate law issue. It may be like a desert, no heart, but he puts heart in whatever he does. He puts his emotion, he put his competence and intelligence, and he's always teaching us new things. Leo, thanks for coming to Brazil. Thanks for being such a friend of this country with your bright ideas, illuminating this generation that wants to work very little, make a lot of money, and to belong to something I don't understand what it is.
I want the same thing.
Thank you very much.
Well, Leo, thank you very much for being here. And especially today, we have faced a problem that is not particular to corporation law. The fact is that the world is changing in such a speed that we have big problems in adapting the law. We have to obey the law. And the law is what is the law until it is changed. But the world changes in such a speed that we have, in fact, a big problem in interpreting the law in a way that faces the new realities and at the same time don't going away from the law. This is a big problem, and I think you have helped us very much. You didn't give us the solution, because this problem has no solution, but it must have a solution in each case, case by case. But next year, yes, next year here. Thank you very much.
Yes. You know the problem, Leo. The problem that we face
No, I'm actually not. They're not judicial activism. Oh, you mean the problems?
Yeah, because we not change. Because the thing is,
no, and that
we lose an election. We lost. Because I will never vote for something like that. We lose an election. The result of the
Another grandson.
Another grandson.
Who is a
Yes,
lawyer.
I am.
He is a lawyer.
I graduated. How many total do you have? How many total grandchildren? Seven. So where are you working
Only
now?
one is beautiful.
I work with arbitration. Yes. You? No, him.
He has one granddaughter and 7 grandsons.
Yes.
Oh, so you have 7 grandsons and you have 8
Yes.
grandchildren?
No, six
boys and 1. 6 and 1. There is only one that's
ready.
2 lawyers.
And my only granddaughter, she entered the law school now. We will
So
have 3.
we are going now to 3 lawyers, grandsons.
2 sons and 3 grandsons. Everybody.
It's nice meeting you. I love your actions.
So, and his left wing, so.
Yeah, I like the lot.
This is
I'm gonna have to have a.
I already introduced him.
Thank you.
I am. And a lot of Americans become, it's a big. Shut up, man! Shut up, but it actually is around the world. Well, you know, it's American. You can actually talk about it. Yes.
Oh, I know.
I'm still like, it's like rip my heart out. I mean, you guys, I still can't believe it.
Andre is a football expert.
He is. He probably is the only person.
Yeah.
In the Caio,